Hi there, my name's James Perry. I'm a consultant solicitor and I'm currently chair of the Law Society's Civil Litigation Committee at national level. I wanted to put together a short presentation today, basically on how I think critically as a litigator. I've kind of spotted that customers and clients probably understand that we have to go through court process to actually solve civil and commercial disputes, but actually how do we go about trying to solve the dispute itself? And I think that's probably something that I haven't really come across a lot of commentary about it. So I wanted to give you some views on how I actually go about it because I thought that might be useful to you. Okay, then, so what do I do? Well, there's a few points to raise here, some quick points. What I try to do as a litigator is I try to adopt a method, a certain method every time I have to consider something. And this starts as a rigid template, but it has the ability to flex. And the reason why I do this is because I do litigate across a broad spectrum of different types of law. What I would say is then is when you're dealing with your litigator, your lawyer, what approach does your lawyer take? Because one thing I would say is that practicing litigation is far, far more than just going through the motions, step after step after step of pre-action, letters of claim, responses to that, issuing proceedings, looking at defence, doing case management, dealing with disclosure, maybe looking at an expert, doing witness statements, and then off we go to trial. Those are the steps of litigation, but what does your lawyer actually do to solve the problem in front of you? Because my view is, and this is the last bullet point, you only protect your client if you have at the forefront of your mind an actual plan to solve the problem. What is the plan? What is your lawyer going to actually do for you to get you that quick result? So as a starting point then, and this is kind of key in everything that I do, is choose an answer, not because it feels right. And there's a few elements to that. So there's a lot of people in the world who have, act on conviction, and I tend to call them, conviction terrorists. They're so definite in what they're saying, and I always think that that's a huge risk in litigation. Also, we have lots of clients who think one thing and they're actually driven by emotion, and that's no good either. So what we need to do as critical thinkers is to really scrutinize what's being said, be skeptical as well of what is being said, and you're skeptical of it to actually stress test it. Because I think if you scrutinize things and if you're skeptical about things, then really what that equals is what you're left with, which is what you need, which is useful and reliable information. And if you do that as well, it will save cost and time in the long run when you're actually dealing with the dispute. So what are my steps then? What's my general plan? What's the framework that I use on a daily basis? Well, first of all, I formulate my question. It's pretty simple. There's no magic behind that. I look at what I actually need to achieve, and I ignore really what you know I don't need to achieve, which is getting one over on the other side, getting rid of the emotion of things. What I'm looking at are remedies. What remedies can my client achieve from the situation they're faced with? So to formulate the question, then we need to do two very simple things. We need to know what we're actually looking for, and we need to know why we're looking for it. So that leads into remedies and what you actually want to achieve as an ultimate outcome at the end. Once you've got your question, again, dead simple, you gather your information. But this is a really, really important step in litigation. I see it done badly time and time again. And it's done badly because it's not properly embraced. And we need to be, as a profession, really disciplined about it. There needs to be some method behind how you go about gathering the information and what you actually do with it. Only good information gathering helps you to weigh up all the options, which helps you to then make good, solid decisions as a litigator, and that, quite frankly, is what it's all about. So gather your information. So you've got your question or questions, you've gathered your information, and now the third sort of step is you need to apply the information in an objective way. And I've set out a few things here. You need to decide what concepts are actually at work. What is it that's at play? You need to recognize what assumptions actually exist, so you don't fall then into any traps. And you see I've lifted there bias traps. Don't be directed in a particular way because that might suit you or because it might suit the client. You've got to look at everything objectively. You've got to weigh up everything to be able to see and to have a little bit of wisdom as to how things might actually play out. And then ask yourself a couple of questions. First question is the information logically sound? Does it make sense? Quite simple, you'll have views on that, but map out those views so you've got something to actually discuss between yourselves. And then ask yourself, what's actually shaping your approach here? What is it that's kind of driving things in a certain direction? And I think once you've done that, you've started to then scrutinize the information you've been given, and you can really begin to form a plan, as it were, of attack to actually get the outcome you want from the case. So what you tend to do at this stage is you've gathered all the information together and you've started to look at all the possible options, and then from that you're looking at kind of your preferred option and you're considering the implications of that option, so you're beginning to stress test it. And you've got to necessarily look at whether or not there are any intended consequences at play. So what could happen if you decide to proceed down this particular path? What are the possible outcomes? Because again, that's the only way you best protect your client. And I think as a final point, which is as equally important as all those other steps, is that I explore other points of view and I don't just dismiss them. Because once I've explored the other points of view, then I can decide on what my decision needs to be. So in order to do that, again, quite simply, is you need to open your mind to other views. Yes, you might be driven by emotion if you're the litigant, and yes, you might be dead set on just one perspective. But what you need to do is you need to open your mind to the other views at least, even if you don't agree with them. You need to ask yourself, why do those other views actually exist? What is it about them that's driving those views? And you also need to ask yourself how many people support the opposing view and why. Because if there's a big crowd of people, then you really do need to consider, is that correct or not? And certainly in terms of witness balancing, simple point is if you're saying one thing and half a dozen people are saying another, then you need to recognise that obviously as a risk. And you need to be careful as to how you then proceed and what your general approach is to the whole claim, probably. So always explore the other points of view and then decide. And that's it. In only 8 minutes, that's pretty much everything. So all you're doing is you're framing your question, you're gathering your info, you're applying the information in a sensible way, you're then evaluating and pre-picking the best outcome, and you're looking at the implications of that best outcome, and then you're considering all the other viewpoints, and from that you're then making your decision. And for me, that framework is the best way to protect a client's best interests, which is my job ultimately. My job's not about going through each litigation step. I'm not there to just help my client move from one step to the next. Protecting best interests for me is about solving the dispute, solving it fast, because fast equals cheap, and that means engaging in critical thinking right from the start to rank your best points and use those to negotiate the best possible outcome for your client. So that's it. That's a 10-minute whirlwind tour of how I'm going about my daily business. If you ever want to chat on any of these elements, or you have a dispute, or you want to talk something through, then by all means get in touch, and I'm quite happy to help. Many thanks.